The most asked questions about estate planning. Number one, do I need an attorney to help me with my estate plan? And the answer to that question is, you probably should. You probably shouldn't be doing that on your own. You should probably seek counsel. What I would recommend to save time and energy and money is go through, we've got a decent amount of content here that you can go through, that you can take a look at to be able to understand a little bit more of what you know about it. My father would always say, do you understand all you know about it? We've created this resource for you to be able to get information, to be able to be a little more enlightened of layman's terms of estate planning, which really just means stuff, and how you're able to manage that stuff while you're alive and also get it to where you want it to go when you pass away, quickly, easily, efficiently, from a tax and everything else standpoint. Another asked question, can I change my mind afterwards? What if I spend all this money, all this work, all this effort, and then I think, I don't want to do it like that, I want to do it like this. You can change your mind through an amendment to your own estate plan. It's really easy. It's easier than setting it up from the beginning. Do I need an estate plan? That's a frequently asked question. Everyone has an estate plan. The state, your state that you reside in, has predetermined if you don't do anything, if you don't create any legal document, they've already decided who's going to make decisions on your behalf, which is going to be who the judge decides after you go through what's called conservatorship. The judge is going to make the determination of who's best to be making that decision, whether it's a neighbor, whether it's a family member, a son, daughter, whatever the case is, has to go through, and someone has to be able to get conservatorship to make decisions on your behalf. And then estate plan from the state, your stuff is going to go to next of kin minus any creditors or anyone else that believes that they have a reason to have some of your stuff. That's your estate plan that's automatic by this estate, and no one wants to go out that way. It's best for you to have an estate plan, whether it be through beneficiaries, whether it be through transfer on death, or whether you end up hiring an attorney to be able to put together all of your different assets that you have in your state, all of your stuff, so that it's sure to go where you want it to go. You're able to be tended to while you're living, and as you are unfortunately making the transition, and once you do pass away, I like to say get your promotion going on to where you want it to be. The next question is, how do I find a good attorney? I think this is probably the very best question to ask. How do I know my attorney is a good attorney? How do I know they're qualified to do what it is that I need them to do? How do I know that they specialize in my area of need? And how am I sure that I'm not calling on an advertisement, that I'm actually going to get a person that's doing my work that is the best and not some brand new person that really doesn't know that much about it, that doesn't really ask the best questions? It's tough. We've provided a checklist, and there's a checklist, we'll make it available to you, to be able to ask the right questions of the attorney to increase the odds of you getting the right attorney. And if you would like us to refer someone to you, and there is someone that we know in your area, we will refer them to you so that you are able to find an attorney that we've at least done some background check on, or hopefully have had some extremely good experiences with them, and we can say, yeah, we've had this client, this client, this client, this client. Go to them. They're fantastic. They're very good, and you should have a good experience with them. What's the difference between a will and a trust? Very simply, a will is a public document that when you go through the process after you pass away, everyone can see it. They can see what you've had. They can see who it goes to. It has to go before the court. The judge has to what's called probate the will, which means give time for anyone and everyone to say, well, I think I deserve part of that estate there. I think that he told me that he said he was going to give me that car that he's got. And it's an opportunity for anyone to come in and say, I deserve part of this. A trust, on the other hand, is completely closed off. No one sees it. No one needs to see it unless there's a lawsuit that requires to open up the trust to see everything that's inside of it. No one's going to see your stuff. No one's going to see who's getting it. No one's going to see anything about it. It's all done behind the scenes with a trust. What else do I need to consider? That's my favorite question. Whenever I'm meeting with a professional, I'll ask them, okay, now, thank you for answering all those questions. And being an engineer, I always have a lot of questions. And then my final question is, well, what other questions should I be asking? What other things should I know? And that's why we created this resource through FundMax to be able to give you the ammunition to be able to ask questions, to be able to find out things that you should be knowing, things that you should be curious about, to give you ammunition so that when you are meeting with a professional or if you're talking to someone at our office, whatever the case is, you're able to get, I'd say you're able to get on the right track of finding what you're looking for and knowing what you're looking for sooner rather than later. These tools are to help you be your own advocate, and of course we're here to be your advocate as well, to be your own advocate in getting what it is that you expect as you're enjoying the freedom in retirement so you're able to, of course, retire happily ever after. How do you store your estate plan documents? People will say, make sure it's printed on great quality paper so that it doesn't tatter, it doesn't decay over time. Some talk about putting it in form of a PDF or on some type of cloud service. I highly recommend that. And most importantly, keep it electronically and keep it with all of your other stuff. If you get anything from this, you want to write this down. Write down a summary. Have a summary page, a one-page information, just like you do for an executive report. Who's going to be in charge? Who's going to be managing it? Just a brief list of who the attorney was, when's the last time you updated your medical and financial durable powers of attorney, the last time you updated your trust, because what's going to happen is if it's not all organized, they're kind of going through and they say, oh, he made the power of attorney his daughter, 15 years ago. Okay, wait a second. He made the power of attorney his son 7 years ago. And then, oh, wait a second. Here's another power of attorney document where he made the power of attorney document back to her 3 years ago. And here's the irony. Whoever's looking at whatever document, whether it's the first one, the second one, or the third one, how do they know? They don't know that there's any other documents. Do yourself a favor and keep a summary of all of your stuff, all on one page, the last time it was updated, what attorney updated it, the date, who it is, if possible, all condensed into one page. And I would recommend the way we do it with our app, with all of our clients, we keep it on an app on your phone so you have this is where the whole industry is going, and we keep it on an app on your phone and you're able to have access to it. And if you want to send it to someone, you can easily send it to someone electronically. Everyone always knows where it is all the time because it's right there for you electronically. The question was how to store your estate plan documents. Don't keep this giant book, that 3-ring binder that someone pulled out this section because they had to get a copy of it, and then someone pulled out. And then I think that maybe it's back at the attorney's office. If you keep it electronically, everyone knows where it is all the time. Keep that summary sheet. Everyone knows where everything stands all the time, especially if your family situation is more complex, if you've got a mixed family, if you have any other atypical uniqueness with your family, you want to be sure you keep it electronically. Everyone knows kind of a broad idea of where you stand, and it's easy to share, it's easy to use, it's easy to implement. Are there tax fees on an estate plan? People will often ask the question, well, what happens? How is all of this stuff taxed? What's the estate tax? First, let's talk about the biggest potential tax is the estate tax and how it applies. If you're married, your estate tax is going to be around assets over $10 million. So if there's over $10 million of family assets, you need to have a plan, and you can have a plan to avoid the estate taxes. If you're single, over $5 million, you need to be managing estate taxes, and they're expensive. The other kind of taxes are income taxes, and those are on assets that have accumulated income. Some of those, well, many of those are going to be optional of when you pay them, and some of those are going to happen immediately. You can't stop it, you can't change it, there's nothing that you're able to do. The reason we're doing this topic is it is so vitally important, So many times people will come to us after the fact. They've already done a triggering event. They've already initiated what requires all of the taxes to be paid right now. And they come to us and say, well, how do we fix this? And it's too late. Before you do anything, when someone passes away, I'd say call a financial professional, but so many times they don't necessarily know because it's not their area of focus. Call us, contact us, let us know. I've got a specific question. Mother just passed away. We've got all this stuff. We need to know how this is going to be treated from a tax standpoint. In summary, the fear people have about estate taxes, usually they don't apply to you. But income taxes, however, it's literally, it's significant. I was going to say life and death financially, but it's huge financially how you pay your income taxes when someone ends up passing away.
What's the difference between life insurance and traditional investing?
There's one key component with life insurance is that the IRS calls it tax-free, just like a Roth IRA. But when you put money into it, once you put it there, it's tax-free, it grows tax-free, it's tax-free forever. Someone is going to get that benefit tax-free because the government says so.
So I have a lot of clients in my 60s who are looking forward to their upcoming minimum distributions they have to take, and they're wondering what are they going to do with all this money they have to take out.
That's a common problem. When you get 70 and a half, you're forced to start taking money out, and you think, I don't need this money. It's just going to add to my income taxes. What can I do with it? And that's a great example to be utilized for life insurance, where you're putting the money in after tax, and it comes out tax-free, whether it be for your spouse, whether it be for your children, whether it be for your grandchildren. Someone is going to get that money tax-free. In addition, there's types of life insurance today that actually will give you a living benefit.
What do you mean by living benefit?
The living benefit is a rider that's inherent into the life insurance contract. So if you're not able to do 2 activities of daily living, which are the things that would require you to get up and go someplace, getting out of bed, going to the bathroom, eating, bathing, taking medications, changing your clothes, if you're not able to do just 2 of those things, you're able to receive a portion of that tax-free benefit from your life insurance contract to be used at your discretion. You can use it to do whatever you want. It doesn't have to be assisted care. It doesn't have to be long-term care. It can be used for having someone coming into your home and tending to you so that you're able to enjoy the freedoms of staying in your home and be able to utilize some of those retirement assets that you have. How does elder law affect estate planning? And this is in the area of how do I know that I'm talking to the right attorney that's giving me the right advice? Elder law is planning that focuses more on when seniors, as you're aging, are not as easily able to manage their affairs in their infirmities, whether it be physical or whether it be neurological. Elder law focuses on how to pay for assisted care, in-home care, to aid in you being able to get around, to be able to do the activities of daily living. You want to know what these 6 activities of daily living are. And there's bathing, dressing, taking your medications, preparing meals, toileting, transferring, anything that you have from a neurological or a physical standpoint that would be a hindrance to you being able to do the 6 activities of daily living. Elder law attorneys specialize in helping you with those transitions, whether it be medical and financial durable powers of attorney or your estate plan, helping you with that transition while you're alive, having your stuff do what you want it to do, and when you pass away, having your stuff go where you expect it to go. Why do I need a financial power of attorney in my estate plan? Why do I need a medical power of attorney in my estate plan? And it's real simple. When you're younger, and you remember when you were under the age of 18, remember you couldn't do things without your parents having approval, your parents, your guardian, whoever it was, being able to sign on your behalf or act on your behalf. And the same thing happens as you age when you get to a point either physically or neurologically, and you're not able to do things. The court in your respective state decides we have to have a plan for someone to have responsibility of making these decisions for this individual. And I'm starting to laugh a little bit, but it's not funny at all, like a child. It's called conservatorship. Someone who has a legal ability to act on your behalf, whether it be financially or whether it be medically, to be able to do what is in your best interest as approved by the court system. They have to go back to court maybe multiple times a year, give an account for every little thing that they're doing, that they're not doing. It is cumbersome. It's a super big deal. And my classic line, it doesn't have to be that way. If you set up your financial and medical durable powers of attorney in advance, you decide who's going to take care of you, you decide who's going to act on your best interest, you decide who's going to execute the directives that you have about your care, and then they're able to just do it. They don't have to go to court. They don't have to answer to anyone. Of course, they're responsible to you to be doing what's in your best interest, but whoever it was that was going to be doing it had to do that anyways. Highly recommend the financial and medical durable powers of attorney. No matter what your age, you could get into an accident, something could happen. You want to be sure that someone's there to be able to act on your behalf. A question that people have is, what's a fiduciary? Are you a fiduciary? Why should I trust you? How do you answer that?
Yeah, so a fiduciary has a couple different meanings, but just in general, it means someone who's required to act on a very high standard in the best interest of someone else. So lawyers are kind of fiduciaries where we have to be loyal to our clients. We have to give our clients all the options and tell them what we think the best recommendation is for them, but the client ultimately gets to decide. So a lawyer has to act in the best interest of their client.
How to prepare funeral expenses and final arrangements, things that you should know, things that you should be tending to make sure that you're not doing incorrect and you're doing the right things. The reason I'm doing this, people ask me, is it okay to prepay? Is it okay to give somebody money, and are they going to actually be there? Are they going to be there in business? Are they going to be there with me when I actually end up needing it many, many years from now, hopefully, when I actually pass away? So here's the thing. You can include directions in your will or in your trust about what type of arrangements very specifically that you want. You can designate a funeral representative, it would be a person, probably a family member, to make those decisions or to carry out the decisions that you've already decided. It's fine if you want to prepay. This is what you want to check on. You want to write this down. You want to ask where the money goes. It should be assigned to a trustee account that's set up on your behalf and the behalf of everyone else that's prepaid, so that if something happens to that institution, to that funeral parlor company, that your money's still there and someone else is able to act on your behalf and do what you were intending on doing, of getting the funeral expenses, the arrangements that you pre-planned done in advance.